Guardianship is a question that we tackle on a fairly regular basis, unfortunately. The concept and process of guardianship is dealing with a child, a minor, who needs somebody else to step in and provide care because a parent is either unable, unwilling, or it has passed away and not able to provide care for a child. So whenever parents have passed away and a guardianship, a person needs to be appointed by the court in order to raise a child, then a guardianship is the remedy to do that. And by the way, when parents have wills, they can identify who they want that guardian to be, and that is the first priority, the first person that the court is going to consider in terms of whom to be appointed if a guardianship is necessary. Sometimes, though, it's involuntary. Sometimes we run into cases where we have a family member, usually a grandparent, maybe an aunt or an uncle, where there's a child in the family who is at risk. Typical situation is one parent is not in the picture at all for whatever reason. Maybe that parent has passed away or has never been part of a child's life. And the single parent who's really there may have an issue, maybe illness. It may be a substance abuse problem, something like that. And so we need to get an order where somebody steps in order to take care of the needs of the child. That gives that person the ability to be able to make medical decisions, to communicate and have access to school records, participate in deciding extracurricular activities, basically being the de facto parent or parents for that child. It is similar to a conservatorship under California law. A conservator is appointed when we're dealing with an adult person who needs somebody else to make decisions for them. Guardianship is when we're dealing with a minor child. But it's a very serious situation, and sometimes it arises when there may be a Child Protective Service complaint or concern raised, and Child Protective Services may talk to family members about whether or not they're willing to step into the process of intervening by filing a guardianship petition with the court in lieu of having a CPS investigation and court process involved. So sometimes that can avoid the process of having to go through CPS. Sometimes a parent is even willing to consent to do that as opposed to having a CPS case move forward. But guardianship, by the way, and conservatorship can be divided into two parts. We can have guardianship over the person and guardianship over the estate. Guardianship over the person deals with the personal decisions and authority to make personal choices that are necessary for that child. Guardianship of the estate often is not really necessary. If a child has assets that need to be managed, then guardianship of the estate is available as a remedy to ensure that somebody is in charge of investing and managing resources that are really owned by or for the benefit of the minor child, in ensuring through the court system that those assets are protected as best as possible for taking care of the children. Sometimes I think of a guardianship case as maybe a quasi-CPS case or a private CPS case. I can think of one example specifically where I had a client a number of years ago, a grandfather, whose son, unfortunately, was in prison, was going to be there a long, long time. His daughter-in-law had a substance abuse issue. They had a 1-year-old child. Nobody was really taking care of this baby. Although there had been multiple CPS reports made, there wasn't enough evidence or nothing conclusory anyway for CPS to be able to intervene in order for somebody to take care of that baby. Baby too young, obviously, to voice concerns or to tell anybody that there were problems and issues. But through guardianship, there was enough evidence for grandfather to be able to get custody of that baby in order to make sure that that baby's needs were being met and protected and taken care of. And until mom maybe could get the help that she needed in order to step up to the plate. So sometimes people have concerns, and maybe CPS doesn't really get involved, but there's enough there in terms of evidence for the court to ensure that the child is getting the protection he or she needs from a bad situation. Special needs trusts are sometimes important because what is often the situation when a child or a person has the availability to receive public resources because of whatever impairment that he or she has, it can limit their ability to inherit something that they otherwise would be able to inherit. In other words, if they inherit something and they are receiving benefits as a result of their needs, they could become disqualified for receiving those benefits. So by setting up a special needs trust, either on its own or as a component of a normal estate planning trust, the benefactor, the person who's setting up the trust and making the gift for the beneficiary, can ensure that there is protection so that those monies and assets are set aside, can be used for the benefit of the beneficiary as needed, but those assets can be used without disqualifying that person for the public assistance or benefits that they may need in order to sustain day-to-day living.